The Keyes case raises a question of waiver. While a psychotherapist patient privilege exists under Pennsylvania statutory law and exists under federal common law, and it's the federal common law that we're dealing with here, while that exists under both jurisdictions, the question in this case is, under what terms could a person waive that privilege? So that if the court has possession of various documents or can obtain possession of various documents that relate to the psychotherapist's treatment of the patient, at what point has the defendant waived his or her privilege to keep the court from considering those documents and those, or the testimony, in fact, from the psychotherapist? And the court says in Keyes versus Sessions that any time that you place at issue your mental health, then you have waived your right to maintain the secrecy of these documents. Much like if the state cannot compel you to go to a doctor, but if you are suing someone who you claim hit you in a car, and you claim whiplash, the other side can in fact require you to obtain a medical examination to confirm or dispel your contention that you have whiplash. So similarly here, if you in your lawsuit raise a claim that you are mentally sound, then you have put at issue your mental health, which means that you have waived this privilege you have about documents, records, testimony that would thereby be relevant to the claim that you're making. And in this case, this is a former serviceman, former state trooper who went through this very emotional divorce that led him to apparently go on a bender, become suicidal, for which he was involuntarily committed. And as part of that procedure, there's a state statute and a federal statute that then created a disability that prevented him from owning a firearm. And his contention is that the Second Amendment prohibits that disability from affecting him because he is not currently laboring under that mental condition that led to his involuntary commitment. And so the court says that the nature of his pleading, the nature of his claim, negates the privilege he would otherwise have for the psychotherapist-patient relationship. And so if you put at issue something that would possibly be negated by those things contained in privileged communications, then you've waived that issue. Very similar issue comes up with lawyers. So let's say that you don't pay your lawyer and your lawyer sues you, and your defense is, my lawyer did lousy work for me. Or you sue your lawyer for malpractice, something that brings the lawyer's work into issue in the lawsuit. At that point, even though the communications between you and your lawyer are otherwise privileged, the nature of your lawsuit has made an issue out of those things that are contained in these privileged communications. So you can, in fact, waive. One way to waive your privileged communications is to disclose them to third parties. Another way to waive privileged communications is to make those issues, make those communications an issue in a lawsuit. And so in this case, the court holds that the actions of Keyes had effectively waived the otherwise privileged communications between the psychotherapist and patient that would have otherwise existed by statute under Pennsylvania law or under federal common law.